another courtroom also in the country's capital. It's the litigation involving the DA, who's pushing back against the country's employment equity laws as they currently stand. By the way, also keeping a close eye on the memorial service for those 3 constables in the Free State. Those are visuals we're beaming to you from Bloemfontein in Bobby's Park. That memorial service will start at midday. But for now, let's take you to the High Court in Pretoria. Continue listening into the DA's arguments against the Employment Equity Amendment Act.
One based on the functionality argument that you heard me address this morning. But that is insofar as the pleadings are concerned. Parliament's answers to be found, milady, at 0412, milady, where they deal with the tagging arguments. And that too is an admirably succinct response. They raise no facts. They merely deal with the matter on the basis that we've incorrectly understood the provision. You will see from paragraphs 16 to 26, milady, that absolutely no factual detail is provided in response. So the suggestion that had we referenced 195, there would suddenly have been a fundamentally different response, and reams of facts would have been placed before the court, which are now not placed before the court. Is with respect, milady, understandable they'd make the submission but not supported by the facts. There are no facts. And the case is a very simple one. The authority for the propositions, we've uploaded the cases onto case lines, milady. I'm going to give them to you briefly. It's Barkhuizen versus Napier, decision of the Constitutional Court, at para 39, where the court makes the point that the mere fact that a point of law is raised for the first time on appeal, which is not the case here, we're raising it here, milady, but even if it's raised on appeal for the first time, is not in itself sufficient reason for refusing to consider it. If the point is covered by the pleadings, and if its consideration on appeal involves no unfairness to the other party, this court may, in the exercise of its discretion, consider the point, and then unfairness may arise, for example, where the facts might have been otherwise, had the issue been crisply and squarely raised. And authority for that proposition, my ladies, inter alia, the case of Paddock, Motors v. Ingersoll, the 1976 decision of the appellate division as it then was. The Paddock decision, my lady, makes the salient point, and it appears that was not uploaded, so I apologize for that. We will, with the court's leave, upload it, my lady. But the authority is Paddock Motors, Pty Limited v. Ingersoll, 1976-3, SA 16 at AIM, brackets AIM, lady, and it's at pages 23 to 24. And at 23, Johnson J.A. makes the following point, which we submit as the point. Is the authority for the submission I just made to you. With reference to what Innes J. said in Cole v. Government of the Union, a 1910 case, Johnson J. 23D to E says the following, milady. For this reason, the raising of a new point of law on appeal is not precluded, provided certain requirements are met. If the point is covered by the pleadings, and if its consideration on appeal involves no unfairness to the party against whom it is directed, the court is bound to deal with it, and no such unfairness can exist if the facts upon which the legal point depends are common cause, or if they are clear beyond doubt upon the record, and there is no ground for thinking that further or other evidence would have been produced had the point been raised at the outset. In presence of these conditions, a refusal by a court of appeal to give effect to a point of law fatal to one or other of the contentions of the parties would amount to the confirmation by it of a decision clearly wrong. And that's an extract from Innes J. in Cole's case, and then in Paddock the court goes on that it would create an intolerable position if a court were to be precluded from giving the right decision on accepted facts merely because a party failed to raise a legal point as a result of error of law on his part has also been accepted by this court in Van Rensburg v. Van Rensburg. And that, my lady, is the position in law And in page 23, letter H, the court deals with the facts of that case where in fact there was a concession as to the law point and says, does that make a difference? And then answers the question, I think not. So even in the face of a concession, the court will not be constrained or not refuse to deal with the point of law. The last reference I'm simply going to give you is a more recent Constitutional Court authority, my lady. It is Botha v. Smuts, square brackets, 2024, ZACC 22, my lady. And it is at paras 63. So those are the legal arguments. Then getting to the thrust of the matter, my lady, there are two scenarios in terms of 76.3 where a matter must be dealt with in terms of 76 and not 75. The first is the one you heard me address earlier, and that is, does it fall within a functional area? The second one is this, my lady. Or provides for legislation envisaged in any of the following sections. And we highlight section 76.3 D, my lady. That is the reference to sections 195.3 and 4 of the Constitution. So if the legislation deals with a matter envisaged in 195.3 or 4, it must be dealt with and tagged as a section 76 bill. Now, 195, my lady, 3, the one we rely on, says, national legislation must ensure the promotion of the values and principles listed in subsection 1 of 195. Do you have that handy, my lady?
Yes, I have it.
So that is 195.3. National legislation must ensure promotion of the values and principles. The one we rely on specifically for purposes of the argument, my lady, is 195.1 195.1I, my lady, which is the requirement in the Constitution that public administration must be broadly representative of the South African people with employment and personnel management practices based on ability, objectivity, fairness, and the need to redress the imbalances of the past to achieve broad representation. Now we say, indisputably, it's not a matter of rocket science. That is what the Employment Equity Act deals with, my lady, and that is what the amendment deals with. And if we're correct in that submission, which we submit we indisputably are, then that is the short answer to this case, because then it is legislation contemplated in 195.3, read with 195.1I, my lady. It clearly, and then you do not get into the more complicated aspect that I addressed this morning about functionality, my lady, and why it does intrude into Schedule 4 function or functions. It's a crisp question. Is it legislation that is dealing with public administration, the need for public administration to be broadly representative, and does it seek to redress the imbalances of the past to achieve broad representation? I invite my learned friends. I've seen the argument, and I'm going to address it briefly.
All right, live visuals for you. The High Court in Pretoria, that's where that litigation, as I mentioned, is still ongoing. The DA challenging the country's Employment Equity Amendment Act.